Hello CA Inter students, myself DV Subramaniam, practicing chartered accountant and qualified cost accountant, and I got 3 all India ranks in CA and CMA examinations. This video is all about revision of exceptional topics. You can expect 60 marks from this particular marathon. Getting it? See, last time, May 2025 attempt, I did a video on exceptional topics, that is, most unexpected topics. That attempt, from this document, 30 plus marks came. And same video, same document, in September 25 attempt, we got 59 marks. We got 59 marks from the same document, same video. I already marked the question, points which was tested in September 25 attempt. I already did a video and already available on my channel. So you can see it. So all the things, all the questions that came from this PDF, I marked like this, MCQ 2, next one, question 1B, question 3B. So like this I marked, last time the PDF is just 14 pages. Now this time the PDF is of 20 pages, 40% content I increased. Getting it? In each and every section, I have gone through the tricky points, exceptional points. Getting my point? So if a question comes from these exceptional points, you should not feel panic. You know what? Fear kills confidence. Getting my point? Automatically you will lose the memory. You will forget the answers. So my main agenda is to boost up your confidence. So confidence will kill fear and you will perform better in the examination. Getting my point? So you can download this document from the website, which you will find it out in the description. In the video description, you will find a link where you can download this document. Now, let's continue the marathon. Okay. See, first of all, we are having total 15 chapters. In Companies Act, we had 11 chapters. LLP and other laws, we had 3 chapters. General Clauses Act, FEMA, Interpretation of Statutes. So, out of 15 chapters, I prepared exceptional topics PDF only on 14 chapters. Only 14 chapters you can find in exceptional topics. That one chapter I ignored is interpretation of statutes. Clear? So chalo, 14 chapters, 20 pages PDF. We are going to have a lot of good time. Clear? Okay. So starting with preliminary. In the preliminary topic, 4 topics are very important. Private company, small company, subsidiary company, government company. In private company, they can ask you a question like this. C Limited, a company, C Limited, a public limited company, having 240 members as per register of members, wants to convert itself into a private limited company. So whether any reduction of number of members required or not, they may ask you a practical question like this. Now you have to see all the past employees and present employees who became members during their employment period will be excluded. Joint shareholders will be counted as single member. So remember this point. Then write the analysis and conclusion. Clear? Next one, small company. Very recently, December 1st, we got a notification increasing the turnover and paid up share capital limits. Of course, those limits are not applicable to January examination. For us, the limits for the time being 4 crores, 40 crores. Remember these limits. Everyone will remember the limits, but everyone forgets these exceptions. Majority students will forget about these exceptions. Public company, subsidiary company, holding company, section 8 company, statutory company, even though their paid up share capital, their turnovers are within the limits of 4 crores and 40 crores, they won't get status of small company. Getting my point? And most important point, turnover limits, paid up share capital limits, you have to verify every year. That means the status of small company is not permanent forever. Getting my point? You have to check preceding financial year figures. Preceding financial year turnover, paid up share capital, you have to check. Based on that, you have to tell whether it is a small company or not. Getting my point? Once lost, forever lost. No, that is wrong. Every year you have to check preceding financial year parameters. Based on that current year, whether it is a small company or not a small company, you have to decide. Subsidiary company. Deemed subsidiary company concept is very important here. For example, C Limited is having subsidiary D Limited. D Limited is having subsidiary E Limited. Now whether E Limited is subsidiary to C Limited or not? Yes, E Limited is subsidiary to C Limited. While checking the control, shares held in a trustee capacity or in a fiduciary capacity should not be considered. Remember this rule. Any shares held by one company as a trustee or as a legal representative in a fiduciary capacity will not be considered for the purpose of determining the control. That is important. And government company, everyone knows government company definition. At least 51% of the capital held by CG or SG, one or more SG, combination of all the governments. But every majority students will forget this point. Subsidiary to government company is also a government company. Suppose IOCL, it is already a government company. So IOCL is holding 50.5% of control in C Limited. Now C Limited also automatically becomes government company. That's it, preliminary over. Okay. Next one, incorporation of company. In incorporation of company, promoter definition is very important. In promoter definition, if you see the last point, third point, a person who provides advices, directions, instructions that board of directors are accustomed to follow, that fellow becomes promoter. But if directors are following a professional advices, advices given by the professional, if that professional is rendering services in professional capacity, then that professional will not be treated as promoter. If professional is rendering services in excess of his capacity, then he will be considered as promoter. In excess of his professional capacity, then he will become promoter. In my question bank, you can see there is a question that one fellow who is a chartered accountant and MBA used to provide tax planning advices and strategic advices, business strategy advices. Is he a promoter? Answer is no, because he is rendering services based on his educational qualifications only. Next one, association with initial formation is not mandatory. To become a promoter, he should not be a one who at the time of incorporation of company must exist. No. Even subsequently also, acquiring majority stake in a company, becoming a managing director, getting some good control in the company, he will automatically becomes a promoter. So to become a promoter, he need not be present at the time of incorporation of company. Next one, OPC. Remember, member nominee, two conditions only they need to satisfy. One is natural person, Indian citizen. That's it. Residential status, not a criteria. Residential status is not a criteria. Only two technical conditions are there. One is natural person. Second one is Indian citizen. Need not be resident in India. If a person becomes member of two OPCs, then person must decide within 180 days to continue with which OPC. That means he should come out of one OPC. 180 days corrective action time period. 180 days is given for taking corrective action. Within 180 days, he need to decide whether to continue with first OPC or second OPC. Getting my point, everyone? See, I'm a nominee in one OPC, member in one OPC. That fellow died. Because I'm a nominee, I become member in that OPC also. So within 180 days, I should take a corrective action. I should come out of one OPC. Getting it? Next one, breach of minimum number of members. Every time, not only at the time of formation, every time, private company should have minimum 2 members, public company should have minimum 7 members. In case of reduction of number of members below the statutory limits, lawmaker is giving you time period of 6 months to increase the number. If not increased, then all the debts, all the obligations entered into by the company after 6 months from the date of reduction, company is not liable, members are personally liable. Their liability is unlimited and members' liability is joint and several. Remember, member who is having cognizant of the fact that business is carried with reduced members only liable, and they are liable not for entire debts, they are liable only for the debts contracted by the company after expiry of 6 months from the date of reduction. That means till the date of reduction plus 6 months. During this time period, company is personally liable, but after 6 months, for those contracts, for those obligations, for those debts, members having knowledge of fact that company is doing business with reduced number of members are personally, jointly, severally liable. Preservation of incorporation documents, MCQ point of view important. Incorporation documents should be preserved at registered office till liquidation of the company. So time period, liquidation, whereas places of preservation, registered office. Next one, section 8 company. In case section 8 company license got revoked, then what would be the consequences? That section 8 company should be wound up, or it should be amalgamated with another section 8 company with similar objectives. That means similar section 8 company. Even after winding up, any surplus left over after clearing the debts shall be either transferred to insolvency and bankruptcy fund or similar section 8 company. You remember these points, okay? One more point, section 8 company. To become a section 8 company, that company should satisfy 3 conditions. One is objects, charitable objects, social welfare objects. Next one, dividends prohibited. Next one, invest surplus in promotion of other objects of the company. Getting it? Next one, entrenchment of AOA. See, you can entrench your articles of association either at the time of formation of company or by way of amendment to AOA. If you are a private company, for entrenchment of AOA, for this amendment, consent of all members is required. That means unanimous resolution is required. Whereas if you are a public company, special resolution is enough. Find out the difference between these two. Find out the difference between these two. Getting my point? Both the cases, communication with ROC is compulsory. Registration with ROC is compulsory. So here the tricky point is, if you are a private company, all members' consent is required for amendment. If you are a public company, special resolution is enough. Disqualifications for change of name, for voluntary change of name. For voluntary change of name, the company should not possess these disqualifications. Sir, what are those disqualifications? Defaults in deposits. Next one, debentures, interest on deposits, interest on debentures. Non-filing of annual returns, non-filing of financial statements. With these subsisting defaults, you are not allowed to change your name. Once you rectify these defaults, immediately you can proceed with change of name. And for change of name, what type of resolution is required? Special resolution is enough. Special resolution is enough. Clear? For rectification of name, ordinary resolution. Don't get confused. Voluntary change of name, special resolution is required. Rectification of name, ordinary resolution is enough. Last attempt that question came, previous attempt that question came. Application, owner of registered trademark should file an application with authority within 3 years of incorporation of that company or change of name by that company. Getting it? Then central government will take appropriate action. It will pass an order to change the name within 3 months. If company doesn't change the name within 3 months, then central government will give a new name. ROC will issue a new fresh certificate of incorporation. And remember, whenever name change happens, along with new name, old name shall be displayed for 2 years. For 2 years, old name shall be displayed along with new name. Next one, shifting of registered office, 4 ways, within same city. Come on, within same city, change in city but no change in ROC, change in ROC but no change in state, change in state. Within same city, equation BR plus ROC. Change in city, BR plus SR plus ROC filing. Change in ROC but no change in state, BR plus SR plus RD approval plus ROC filing. Time limits also I have given, time limits also I have given. Change in state, BR plus SR plus central government approval, in brackets you can see power already delegated to RD and ROC filing. Clear? And you know what? Section 8 company, remember this point. Section 8 company, for alteration of MOA, RD approval is required. Whereas for alteration of AOA, ROC approval is enough. Remember this point, MCQ point of view, important. Alteration of MOA, RD approval. Which company? Section 8 company. Alteration of AOA, ROC approval is enough. Next one, ultra vires. Doctrine of ultra vires. Ultra vires Act can never be ratified even by the whole body of the members. Neither party, that means outsider, cannot sue, cannot enforce, cannot claim damages for an ultra vires contract. Any member can seek an injunction to stop the company from committing an ultra vires act. Member, even with a single share also, even though he's a minority holder, but still enough, he can bring injunction order stopping the company from entering into ultra vires acts. Next, exceptions to indoor management. My dear students, remember this point. They may ask you a question like this: cases where indoor management not applicable or cases where doctrine of constructive notice is applicable. Both the cases answer is same, whether exceptions to indoor management or cases where constructive notice is applicable. Both the questions, only one answer, same answer. So if outsider is negligent, if outsider is having knowledge of irregularity, outsider can easily discover irregularities. The rule does not apply to the forged documents, forgery. If there is a doubt about existence of an agency, whether this fellow is director or not a director, in case of any suspicious events, you have to make further investigation. You can't make an assumption that all the internal policies, internal rules and regulations will be as per AOA, as per Companies Act. No. When a precondition must be met before the company can exercise certain powers. In this case, the act is not just ultra vires the directors or officers, but ultra vires the company itself. So simply, in all these cases, you know what? Company is protected. Outsiders will not get any protection. You remember that point. Indoor management is to protect outsiders, but constructive notice is to protect company. So in these cases where indoor management not applicable, company will be protected, outsider will not get any remedies. Section 19, last attempt also 2 marks MCQ came on this point. This is regarding what subsidiary company should not hold shares in holding company. Holding company should not allot shares to the subsidiary company. Getting my point? But we had 3 exceptions. As a legal representative allowed, as a trustee allowed, before becoming subsidiary also allowed, but in these 2 cases only voting rights is allowed. So in examination they asked question multiple times like this. Yes Limited is holding shares in holding company. Total some 9% of the paid up share capital Yes Limited is holding in H Limited. Out of 9, 7% as a legal representative, 2% as a before becoming subsidiary. Before becoming subsidiary. Now the point is, voting rights is allowed to what extent? Sir, voting rights is allowed to the extent of 7%, that is representing, as a legal representative. That's it. As a legal representative, as a trustee, voting rights allowed. Remaining cases, voting rights are not allowed. Nidhi company, important, not important, exceptional point. So far not tested. If your time is good, this time this point may come. Nidhi company, service of documents, including financial statements. Service of documents to the members holding more than 1000 or 1% of the paid up share capital. Serve them individually. Whereas for other shareholders, simply small shareholders, minorities, that means those who are holding less than or equal to 1000 face value of securities or 1% of the paid up share capital, for them no need to serve individually. Serve by public notice in local newspaper and notice board of the company. Clear? Authentication of documents, deeds, section 22. Bills of exchange can be accepted on behalf of the company by a person acting under implied authority in the ordinary course of business. Implied authority, remember, managing director is having implied authority to accept bills of exchange. Company must authorize a person by written authority signed by either 2 directors or 1 director and 1 CS to execute deeds as attorney. If common seal is there, along with signature, suffix common seal. If there is no common seal, then these people's signatures are required, or else that delegation of authority is invalid. Getting my point, everyone? Apart from these points, the points I didn't cover is, section 6. Section 6. If there is any inconsistency between Act and MOA, AOA, board resolution, members resolution, and agreements executed by the company, Companies Act will always have overriding effect on this. On these things. Companies Act is superior to all these documents. That is section 6. I didn't cover. Section 7, incorporation, documents to be filed for incorporation of the company. You all know, signed MOA, AOA, 2 declarations, details of the subscriber, details of the first directors, and next one, address for temporary correspondence. All these documents filed with ROC shall be preserved till liquidation of the company at registered office. You remember those points? I hope you remember these points. And that subscription also, illiterate person will affix the thumb mark and a literate person will sign below the thumb mark. And foreigners, you can see valid business visa if they are attach it, or else document should be apostillized or notarized. Just go through it once. May 25 attempt that question came, that's why this time I am ignoring that concept. And section 8 I already covered. 9, 10, 11 is not there. 10A, that is a old section only. 12 I covered. 13, alteration of MOA, name change I covered. 14, alteration of AOA, entrenchment a little bit, you can see there. Next one, 15, alteration to be noted. Section 15, alteration to be noted. That is important. Every time when you alter MOA, AOA, that alteration should be noted in the each copy of MOA, AOA. Next, 16, rectification of name, I told you. So that's it, That's all about incorporation chapter. Next, prospectus, chapter number 3. In chapter number 3, prospectus, first one, definition of security. Remember, security excludes unit linked insurance policy. Security include every marketable instrument. Every marketable instrument, yes, security includes every marketable instrument, but security specifically excludes unit linked insurance policy. You remember this point, very important. And definition of listed company, this time I'm expecting this one. These exceptions, the combination you see, public company not listed their equity shares but listed their NCDs. NCD means non-convertible debenture securities which were issued on private placement. Remember the equation, NCD plus private placement, not public offer. Next one, non-convertible redeemable preference shares which were offered under private placement basis, or both the categories. In all these cases, equity shares remain unlisted. Equity shares remain unlisted. Then that company is not treated as listed company. Private company also, you can see here, NCDs which were offered under private placement basis, even though they are listed on recognized stock exchange, it is also treated as unlisted company. And this is a new point. Public companies that have not listed their equity shares in Indian stock exchange but whose equity shares are listed in foreign jurisdictions, permitted foreign jurisdiction, that public company is also not treated as listed company. It is also not treated as listed company. Remember these equations. High chance is there question to come on this point. Clear? Unlisted company, remember ma, public company, equity shares unlisted, NCD plus PP listed, NCP non-convertible preference shares, redeemable preference shares on private placement basis listed, no problem. Both, no problem. Private company, you remember NCD only, non-convertible debenture securities which were offered on private placement basis. Clear? Next one, prospectus. You know, exceptions ma. Rights issue becomes a deemed prospectus if renunciation resulted in offer to more than 50. Remember this point. If renunciation is done in favor of more than 50 outsiders, more than 50 persons outsiders, then the rights issue is deemed to be prospectus. Mere labeling as private circulation does not prevent it from being a prospectus if it invites the public, even though you name it as a private circulation. But if you are inviting public, that's it, it is also prospectus. Prospectus is not applicable in the following cases: when you are offering securities to the existing members, existing debenture holders under rights issue, section 62, it is not a prospectus. Or offered securities which are uniform in all respects with previously issued and listed on recognized stock exchanges, also prospectus is not applicable. You know, prospectus is applicable for both IPO as well as FPO as well as offer for sale of securities, but prospectus is not applicable in the below mentioned two cases. Clear? Okay. Expert statement, last time I think 5 marks question came on this point, so you can ignore it, but very simple point. To include expert statement, first of all, expert should be an independent person. That means he should not be connected to the company's promotion, management, incorporation. He must give written consent to include his statement in the prospectus, and such consent should not be withdrawn before filing with ROC. Everything should be disclosed on the face of the prospectus. Then only inclusion of expert statement is valid, or else it is void. Deemed prospectus, last attempt 5 marks question came on deemed prospectus. Yes. So when an offer will be treated as deemed public offer, the answer is if an issue house, you know, company C Limited is allotting securities in the name of issue house which further offers to the public within 6 months of allotment or at the time of offer, full consideration by issue house to the C Limited not discharged, full consideration not received, not been received. Full consideration means what? You know, for example, this contract value 100 crores. So for company C Limited received 98 crores only. You tell me full consideration received? Full consideration have not been received. Only 98 crores only received. 2 crores is pending. That's it. So even offer is made after 6 months of allotment, but after 6 months, if consideration, full consideration company didn't receive from issue house, then that offer by issue house is deemed to be public offer. Okay. Who signed deemed prospectus? Issue house. If issue house is a firm, at least half of the partners. If issue house is a company, 2 directors must sign the deemed prospectus. Alteration of objects in the prospectus, expected question mark, because so far this point was not tested in the examination. In this, you know what, A point is exceptional point. Company cannot use funds raised through the prospectus for buying, trading, dealing in equity shares of any other listed company even after getting SR. See, for alteration of object in the prospectus, you know, special resolution is compulsory, but you can utilize money for any purpose other than trading of equity shares of any other listed company, listed equity shares of any company. Dissenting shareholders must be given an exit option by the promoters or controlling shareholders. They may confuse you. They may ask you like this, you know, if exit offer is given by the company, is it valid or not valid? If company is giving exit offer, we call it as buyback. So not allowed, not allowed. Shelf prospectus. Shelf prospectus, 2 points, very tricky points ma. Information memorandum which contains new charges created during the period and changes in the financial position must be filed with ROC 1 month prior to the subsequent public offers. After looking at information memorandum, any person who filed application in advance, who deposited money in advance, must be given a withdrawal option. If you choose withdrawal option within 15 days, how many days? Within 15 days of availing the option, refund must be done. Company cannot deduct administrative charges while refunding the money. 100% refund to be done. No deductions allowed. Clear? Red herring prospectus. Red herring prospectus has to be filed with ROC at least 3 days before opening of the subscription list. Before offer gets opened, before opening of the offer, 3 days before opening of the offer, file a copy of red herring prospectus with ROC. Once public offer is done, once you got the details of issue price and number of shares being offered to the public, prepare a final prospectus. Any changes in the red herring prospectus and final prospectus shall be highlighted, or else it leads to the contravention. Clear? Next one, misstatements in the prospectus. Misstatements in the prospectus. Yeah, criminal liability 447. But you have to prove that if statement is immaterial or you had reasonable grounds to believe that statement was true, then you will be exempted from criminal liability. Civil liability, civil liability, what is a civil liability? You have to compensate the investors who suffered loss. But if you're able to take any of these three defenses, you will be exempted from the punishment. What are those three defenses? Withdraw your consent. No sir, already prospectus reached public. Now give public notice. Or else you have to prove that, sir, I believed expert in his expert capacity gave opinion on this prospectus. On the faith of expert statement, I gave my consent to the prospectus. On the faith of expert statement, I gave my consent to the prospectus. Already expert gave consent, expert statement was included in the prospectus, expert didn't withdraw his consent till a copy has been filed with ROC. Either trust, expert give consent. If you're able to prove this defense, you will be exempted from the punishment. But in many previous examination papers, if you see, in the place of expert, the question was on the faith of the promoters, director gave consent to the prospectus. Now whether director get exemption from the punishment, answer is no, because on the faith of promoters you won't get, you can't take a valid defense. You can take a defense only on the faith of expert statement. That's it. Misstatement cases ma, last time these points were tested. But look at this point, misstatement examples. A statement in the prospectus stated directors and friends had subscribed a large portion of capital, which was false. It was misleading. Prospectus claimed the company had regularly paid dividends, which in reality the company incurred substantial loss. It was held misleading due to failure to disclose the full truth. Half truth is always dangerous. It is also a misstatement. Misstatement means false facts or misleading in nature. Either false facts or misleading in nature, both are misstatements only. Okay, so production capacity, but misleading if referring to the actual production level. So court held this is also misleading statement, misstatement. These 2 points are very exceptional points ma. Subsequent purchaser of shares cannot seek rescission, cannot cancel the contract of allotment, and subscribers to MOA also cannot seek rescission. These 2 are exceptional cases, not yet tested, so just give one time reading. Allotment of securities. Until allotment happens, money shall be kept in separate bank account, and that money shall be utilized only for 2 purposes: either adjust against allotment or repayment of money unable to allot securities. You know what? For making allotment of securities, 2 conditions to be satisfied. One is minimum subscription. As per SEBI, minimum subscription should not be lesser than 90% of the public offer. And second condition is minimum application money. It should be not less than 25% of issue price as per SEBI. Clear? Okay, these conditions fulfill within 30 days of making public offer, or else refund within 15 days of closure of offer period. Within 15 days of closure of offer period, refund all the monies. Getting it? Or else directors will get personal liability. They need to pay interest at the rate of 15% per annum. All these rates, if at all possible, on all these rates I'll come up with another video. Okay, we are having 2 days before examination. Don't worry, I'll do all the things that are required to face examination. Underwriting commission. This is exceptional point, ma. Company is offering securities on private placement basis and company wants to pay underwriting commission. Allowed or not allowed? No underwriting commission payable on securities not offered to the public. Getting it? No commission payable on securities not offered to the public. And rate of commission maximum 5% in case of shares, 2.5% in case of debentures, or the rate as per AOA, whichever is lower. 5 or AOA, 2.5 or AOA, whichever is lower. Clear? Private placement, count is 200 persons per financial year, that too per security. Limit applies to each type of security. While counting these people also, qualified institutional buyers, ESOPs, employee stock options, employees covered under ESOPs are excluded, and these limits are not applicable to NBFC companies, housing finance companies. Okay, in the entire private placement, public advertisements not allowed. And private placement should not carry any right of renunciation. If renunciation is there, that is not a private placement, deemed to be public offer. Getting it? In the entire private placement, one more tricky point is keeping previous private placement pending. Keeping previous private placement pending. You can't make fresh private placement. You can't make fresh private placement. Either previous private placement should be withdrawn or previous private placement should be completed. That means allotment should be done. Keeping them pending, not allowed. And the limits in private placement. Day 0, I received money, ma. I received application money on day 0. By day 60, allotment should be done. Allotment should be done within how many days? Within 60 days. If allotment is not possible, then within next 15 days, that means day 75. By day 75, refund of application money should be done. Application money should be refunded, or else from 61st day onwards, let me repeat, from 61st day onwards, interest calculation will start at the rate of 12% per annum. Getting my point? Everyone, within 60 days make allotment or refund within next 15 days, or else interest calculation will begin from 61st day onwards. Voting rights in case of GDRs, tricky point only. Holders of GDRs can become a member of company only after converting GDRs into underlying shares. Until conversion, overseas depository shall vote on behalf of GDR holders. So this is a exceptional point about voting rights. Remember this point, okay? Who will have voting rights in case of GDRs? Who will have voting rights? Depository will have voting rights. Depository receipt holders will get voting rights only after conversion of their depository receipts into underlying shares. 3 chapters we completed. Next one, share capital and debentures. Equity shares with differential rights. Remember defaults, ma. For issue of equity shares with differential rights, remember the condition default MOA. Default MOA. A stands for Articles of Association Authorization. O stands for OR. If you are a company whose equity shares were listed on recognized stock exchange, then such OR shall be passed through postal ballot. Unlisted companies, normal, meeting enough. But equity shares listed on recognized stock exchanges, postal ballot compulsory. And M stands for maximum limit. The maximum limit, voting power from differential rights shall not exceed 74% of total voting power of the company, you remember. Next one, coming to the defaults, company should not have subsisting defaults of repayment of deposits, debentures, interest on debentures, interest on deposits, preference shares redemption, and dividends. And last 3 financial year, company should not default in filing of annual returns, financial statements, are penalized under SEBI Act, FEMA Act, RBI Act, Securities Contract Regulation Act, or 5 years post rectification. That means if you had these kind of defaults like term loans repayment default, interest on term loan, preference dividends, employee statutory dues, IEPF defaults are there. Rectify these defaults, wait for 5 financial years. After completion of 5 financial years from the year of rectification, you are allowed to issue equity shares with differential rights. Conversion not allowed, ma. No conversion allowed. Conversion not allowed. Disclosures in register of members is required. Voting rights. Coming to the voting rights, my dear students, remember this point. 1 attempt 2 marks MCQ came. Nidhi company, in order to avoid concentration of power in few hands, even if a member is holding more than 5% of the paid up share capital of the company, his voting rights is limited to 5% only. Suppose I am a member of Nidhi company, I am holding 1% paid up share capital. How much voting right I will have? 1%. If I hold 10% paid up share capital in Nidhi company, I will get only 5% voting power. Remember this point, okay? Voting power is limited to 5%. If preference dividends remain unpaid for 2+ years, preference shareholders can vote on all resolutions like equity shareholders. Between these two sections, one section is there, that is section 46. What is section 46? Issue of share certificates. Duplicate share certificates is also covered. Remember, my dear students, duplicate share certificates, any fraud is there, officer in default gets punishment under section 447. Company gets punishment of 5 times of such duplication, face value got duplicated, or 10 times 10 crores whichever is higher. Minimum 5 times, maximum 10 times or 10 crores whichever is higher. Remember, penalty. And one more time limit is there. Please. Within 45 days, duplicate share certificate shall be issued if it is belonging to the listed company. Unlisted company, twice, that is 3 months. 3 months. Within 45 days, issue duplicate share certificate. And unlisted company, within 3 months of application, issue duplicate share certificate. Next one, variation of rights, last attempt. This came for 2 marks MCQ. If variation affects right of one class, another class, then consent of 3/4 value of that another class is also required. That means special resolution or 3/4 value consent is not only to be taken from the existing class whose rights are getting affected, but also another class, because of variation, the another class rights are getting affected. Now another class members consent is also required. 2 marks. This point came in the last attempt. Calls in advance. Can company accept calls in advance? Yes, if authorized by AOA. And if authorized by AOA, can accept advance payments. But remember, calls in advance is not a part of paid up share capital, so no extra voting rights for calls in advance. Sir, what about dividends? It depends on section 51. What section 51 is telling? If AOA of a company is telling that dividends should be paid on paid up value, then no dividends on calls in advance. If AOA is silent, dividends will be calculated on face value. If it is calculated on face value, forget about calls in advance. Everyone will get dividends on face value, not paid up value. Getting my point? But in both the cases, there will be no dividends on calls in advance. Getting my point? No extra voting rights, no dividends. Dividend can be paid either on paid up value or face value. Next one. So advance payments do not confer voting rights. Next one, sweat equity shares limits. Issue to be completed within 12 months of special resolution. In between, application of securities premium, you all know that is a minute concept. That's why I'm not touching that concept. Do you remember? Utilization of securities premium, B square, EP square, buyback, bonus issue, expenses connected with issue, preliminary expenses, and premium on redemption of securities for all companies. Whereas section 133 companies which are required to prepare financial statements in accordance with AS, for them B square E is only allowed. Next one, so issue to be completed, sweat equity shares to be completed within 12 months of special resolution. Sweat equity issuance is limited to 15% of paid up equity share capital or 5 crores whichever is higher. Sweat equity issuance must not exceed 25% of company's paid up share capital. This is yearly limit and this is lifetime limit. Getting my point? My dear students, there is an amendment in sweat equity shares which we got it 5 years back. Earlier, to issue sweat equity shares, company should complete 1 year of incorporation. Right now, that condition is not there. Today, company incorporated. Tomorrow, if company wants, it can issue sweat equity shares. If you are a startup company, of course, private limited company only gets a status of startup companies category. So, 50% for startup companies up to 10 years post incorporation, sweat equity shares can be up to 50% of paid up share capital. Clear? Next one, preference shares. Preference shares. Company can issue preference shares for a period of 20 years. But if you are a company engaged in infrastructure projects, for you the maximum duration is not 20, 30, provided every year 10% redemption should be done from 21st year onwards. So by the end of 30th year, balance becomes 0. And conditions for issue of preference shares, AOA authorization, special resolution, no subsisting default with respect to existing preference shareholders. Okay, next one, can company issue preference shares with irredeemable category? No, preference shares should always be redeemable and the maximum duration is 20 years. Even for redemption also the conditions are the shares should be fully paid up. Only fully paid up shares can be redeemed. Coming to the sources, fresh issue, issue proceeds or company profits. If you select company profits, CRR to be created. If you select company issue proceeds, no CRR is required. But after redemption, communicate the same with the ROC. Important point in preference shares is deemed redemption of preference shares. Deemed redemption of preference shares. For that, 3 conditions compulsory to be satisfied. NCLT approval required. For that, 3/4 value preference shareholders should give consent for issue of preference shares in the place of unredeemed preference shares. And dissenting preference shareholders should be paid off. Dissenting preference shareholders should be paid off. And I forgot, yes, I told you, right? Preference dividends which remain unpaid for 2+ years. Along with equity shareholders, preference shareholders will also get voting rights. That means equity capital, preference capital, you total it. Out of that, how much a member holding in the total capital, to that proportionate, to that extent, that member will get voting rights. Okay, registration of transfer of partly paid up shares without notice to transferee, without giving a time period of 2 weeks to the transferee. If company registered transfer of partly paid up shares where application was made alone by the transferor, is invalid. So in case of transfer of partly paid up shares where application was filed by transferor alone, company should give 2 weeks notice to the transferee. That means within 2 weeks, if transferee is not raising any objection, then registration is allowed. If a transferee who acquired shares via forged transfer sells them to innocent buyer and company registers new buyer, then remedy for innocent buyer, company cannot deny ownership rights to the genuine innocent buyer who acted in good faith. Therefore, company is personally liable to the innocent buyer, and company has to restore the name of original shareholder but may be asked to compensate the innocent buyer. Of course, company can seek indemnity from the first transferee, that is the person who was involved in forged transfer. Next one, further issue of shares, alteration of share capital. Section 61, if you take section 61, you take alteration of share capital. In that, 2 points are somewhat tricky points. Point 1 is consolidate and divide. Point 2 is split. In case of consolidate, if voting powers of members is getting affected, NCLT prayer approval is required. In case of split, the face value and paid up value should be split in the same ratio. And one more point, company cannot issue stock directly. First, company will issue shares. Later, shares will be converted into stock. Which shares? Fully paid up shares can be converted into stock. You remember this point. No company is allowed to issue stock directly. First, it will issue shares. If they are fully paid up, they can be converted into this stock. Remember that point. Next, section 62. That is further issue of shares. Generally, for ESOP, special resolution is required. But if you are a private company who have not defaulted under section 92, section 137, for you OR is enough. Ordinary resolution is enough. Even for IFSC companies also, remember this rule. IFSC company also, OR is enough for issuing shares under ESOP. Next one, rights issue. Remember, notice should be given 3 days before opening of the offer, and offer period should be minimum 7 days, maximum 30 days. Minimum 7 days. Of course, if you're a private company with 90% of the members consent, this 3 days duration can be reduced. This time period of 3-7 can be reduced with the consent of 90% of the members. Remember these limits. Next, section 62 does not apply to the debentures or loan conversion. If a company is converting debentures because it issued convertible debentures earlier, you have taken special resolution. Now for the purpose of conversion, special resolution is not required. And CG directed conversion also, special resolution from the members is not required. Earlier debentures were issued to the government, loans granted by the government. Now if CG is ordering to convert these loans into the equity, automatic conversion will happen. Special resolution is not required. Even if your authorized share capital not permits for this conversion, CG order is enough to increase your authorized share capital. Automatic increase of authorized share capital. Next one, bonus shares, revaluation reserves not allowed. Bonus shares shall not be issued in lieu of dividend. I told you many times. What it means? Bonus shares do not amount to the dividend. They represent capitalization of undistributed profits. Undistributed profits capitalization only bonus shares. Getting my point? If you declare dividends, it must be paid in cash only. Bonus do not amount to the dividend. Dividend should be paid only in cash, not in kind. And what is a bonus? They represent capitalization of undistributed profits. Company must not have defaulted on interest or principal payments of fixed deposits, debentures or bonds, statutory dues such as employee provident fund, gratuity, bonus. Remember these defaults. They may ask you, companies having these defaults, can company proceed with bonus issue? Answer is no. Once recommended, once declared, can't be withdrawn. Remember these points. See, this is exceptional topics marathon. If paper is tricky, you will find these points only in your question paper. Getting my point? Okay. Prohibition on purchase of own shares, section 67. Section 67. In between these two, you will see section 66, that is reduction of share capital. Reduction of share capital, it arises in three ways, ma. One is cancellation of uncalled capital, cancellation of unwanted capital, cancellation of unrepresented capital. Uncalled, I'm cancelling right now, or unwanted, I'll pay it off and I'll cancel it. Unrepresented, you will see in internal reconstruction. You will see in internal reconstruction. Getting my points? So cancellation of any of these three capitals, it results into the reduction of share capital. For that, special resolution from the members and RD approval is required. But if company had committed defaults in deposits, reduction of share capital is not possible. Then NCLT will give notice to the authorities. Wait for 3 months, CG, ROC, SEBI, central government, yes, SEBI in case of listed company, and creditors. Wait for 3 months. If there is no objection from these people, NCLT will give an order confirming the reduction of capital. Now register that NCLT order copy with ROC. Fine. More or less, I'm taking on an average 10 minutes for each chapter revision. All points I'm covering. Okay. So if you feel tensed or if you feel stressed, kindly listen to this marathon lecture. All the points I'm covering. But exceptional points, I'm showing on the screen. Okay. So prohibition, a public company cannot provide any financial assistance, loan, guarantee or security to anyone purchasing its own shares in its holding company. But we had 3 exceptions. Lending business allowed. Employee share purchase scheme, purchase value up to 5% of paid up capital plus free reserves. Remember this limit. Up to 5% of paid up capital plus free reserves allowed. Listed companies, valuation, no need of valuation. From recognized stock exchange, you will purchase the shares. So valuation would be independent value only. Unlisted company, valuation by registered valuer is required. And of course, special resolution is required in this case. Employee loan, employee should not be employee should be neither KMP nor director. Maximum finance 6 months salary, and he should purchase or subscribe only fully paid up shares. Just 1 second. One point I need to add here. Yeah. Section 67 is not applicable to these 3 companies, ma. These 3 companies, yeah. A private limited company which satisfy 3 conditions. No body corporate is a member of this private company. Borrowings less than twice of the paid up share capital or 50 crores, whichever is less. No subsisting default in above borrowings. And of course, specified IFSC public company also, this section is not applicable. Clear? Next one, conditions for buyback. Special resolution is required when if buyback is amount in buyback is greater than 10% of paid up share capital plus free reserves plus securities premium. If amount for buyback is within the limit of 10%, BR is enough. Board resolution is enough. Remember these limits, very important. Board resolution is enough if your amount to be invested in buyback is less than or equal to 10% of paid up capital plus free reserves plus securities premium. Maximum buyback in a year cannot exceed 25%. Post buyback debt equity ratio should be less than or equal to 2:1. Only fully paid up shares can be bought back. No buyback within 1 year from the closure of previous buyback. Gap between 2 buybacks should be 1 year. And issue of shares which you bought back, the class of shares where buyback happened, those shares should not be offered for the next 6 months after completion of buyback. Of course, existing obligations like, sweat equity shares, employee stock options, conversion of preference shares into equity, conversion of debentures into equity, issue of bonus shares. For this, you can use the shares which belongs to the class where buyback was completed very recently, that is within 6 months. Clear? Okay. In debentures, this is most tricky point, exceptional point. Who cannot be debenture trustee? Beneficial member cannot be trustee. Even a registered member can be trustee. But if a person is having any beneficial interest in the equity shares of a company, disqualified. Promoter, director, KMP, employee of the company or its holding company, associate company, subsidiary company, cash, group companies, disqualified. Relative of the above people also disqualified. Creditor is also disqualified except remuneration. Debtor to the group company is also disqualified. Surety disqualified, and a person having pecuniary relationship, material relationship, that is, how much the relationship, the total transactions involved between the proposed candidate and company. If it is 2% or more of company's turnover or total income, or 50 lakhs or more during the 2 immediately preceding financial years or the current financial year, then the fellow will be disqualified. Clear, everyone? With this share capital topic also we completed. And the next topic is deposits. In deposits, 3 points found very exceptional points. In the entire chapter, only exempted deposits had a good and decent weightage. You can see here, exempted deposits, easily you can remember. Amounts, loans particularly. Loans received from the government, foreign sources, financial institutions, banks, AIF, REIT, IIT, VCF, venture capital funds, mutual funds, intercompany deposits, all are exempted deposits. Amounts received by, this is by Nidhi company, chit fund company, trust, non-interest bearing security deposit. Company received money as a trustee. If it is a non-interest bearing security deposit, then also it is an exempted deposit. Next one, collective investment schemes, exempted deposit. Next one, amount received through issue of commercial papers, application money pending for allotment up to 60 days, not a deposit. If not, refund within next 15 days, then also not a deposit. Very exceptional point. In case if you are not refunding the money, if you are making any adjustments, then it is not treated as refund. It is not treated as refund. If it is not treated as refund, it becomes a deposit. Exceptional point, ma. Next one, secured convertible listed debentures without charge. Remember, listed debentures without creating any charge. Secured debentures, convertible debentures within 10 years of issue, they are also not treated as deposits. Startup companies, issue of convertible note with a duration of less than or equal to 10 years under a single tranche collecting 25 lakhs or more, it is also not a deposit. Less than 25 lakhs or more than 10 years, exempted deposit benefit will not come. Under a single tranche, amount received by the company should be 25 lakhs or more. Company should be startup, and that convertible note, it should be repaid or it should be converted into equity within 10 years of issue. Next one, amount from the persons, employee up to 12 months salary, that means annual salary plus non-interest bearing deposit. Directors, private company, relative of director is also allowed. Amounts received from the directors. In case of private company, relative of director, but declaration is important. Along with the declaration, what? Disclosures in board report. Board report disclosure is also required. If these conditions are satisfied, then exempted deposit benefit comes. Promoter loans, provided they should be unsecured and according to the condition imposed by the lending institutions. Until the loan with respect to lending institution was repaid off, until that point, unsecured loans from the promoters are not treated as deposits. Business advances, in case contract got cancelled, then refund within 15 days of cancellation of the contract. If not refunded, it becomes a deposit. If not refunded within 15 days of event, it becomes a deposit. Understood? So trade advances up to 365 days adjustment should be done. Immobile property advance, security deposit, long-term project advance, AMC, EWC, standard business practice or 5 years, whichever is lower. Last attempt 2 marks MCQ came. Standard business practice, they told 7 years. 7 or 5, whichever is lower means you have to take 5 years. So if any advance was accepted for 7 years, it becomes a deposit. Exempted deposit benefit will not come. Sectoral regulatory advances, not a deposit. Subscription for publication also not treated as deposit. And you know, this chapter is not applicable to banking company, NBFC, housing finance companies and prescribed companies. Ministry will prescribe few companies for which this chapter rules and regulations will not apply. Next one, deposits cannot be repayable on demand. Must have a minimum tenure of 6 months, maximum tenure of 36 months. Of course, short-term duration deposits are also allowed, provided 10% ceiling. That means deposits shall not exceed 10% of the paid up share capital plus free reserves plus securities premium, and the shortest duration not less than 3 months. Minimum 3 months should be there. And you see, in the deposits chapter, another time limit is within 21 days of receipt of money. Yes, deposit receipt should be issued. It is, listen, it is not treated as a marketable security. Deposit is not a marketable security. There is a difference between deposit and debenture. Debenture is a tradable security, whereas deposit is not a tradable security. Getting my point? Yes or no? And you know, conditions for acceptance of deposits, just one minute point I want to show here is resolution at meeting, ordinary resolution at meeting, issuance of circular, copy of circular to be filed with ROC, deposit repayment reserve, certificate as to no default, provision for security. Of course, these conditions are not applicable to the few companies. Which are the companies? Private companies accepting deposits up to 100% of paid up share capital plus free reserves plus securities premium, startup company, and a company which satisfy, a private company which satisfy 3 conditions. You know, other body corporates should not, this company should not be a subsidiary, not an associate. Total borrowings less than twice of the paid up share capital or 50 crores, whichever is less, and no default in repayment of the subsisting borrowings. For these companies, you know, these conditions are not applicable. These A, B, C, D, E conditions are not applicable. Issuance of circular, filing of circular, deposit repayment reserve, certification as to no default are not applicable. Yeah. Deposit receipt should be issued. This is the point I want to highlight you. Deposit receipt should be issued within 21 days from the receipt of money. For delay payments, penal rate of interest 18% per annum will be added. Joint names not exceeding 3 names. If any person file an application, within that application if 4 names are there, you know, deposit receipt can't be issued with 4 names, maximum 3 names only. Clear? Everyone? Next, please this one point, please tolerate. Maximum amount of deposits, you know, from members 10%, from public 25%. For government company, there is no such bifurcation. Clear? And all registers should be updated within 7 days of issue of deposit receipt. Authentication by the director, secretary or authorized officer. Register shall be preserved up to 8 years from the date of latest entry. That means till the satisfaction. After payment, after repayments, up to 8 years you maintain these registers. Remaining are direct points only. Only these points are exceptional points. These points are tricky points. Remaining just give one time reading. Next one, charges. In charges, you know, crystallization of floating charge. When floating charge will be converted into fixed charge? The answer is when terms violated, company stops operations, company went into liquidation, or creditor enforces security covered by the floating charge. In all these cases, floating charge will be converted into fixed charge. Registration of charges, you know, time limits. Up to 30 days of creation of charge, normal fees. 30 to 60, additional fees. 60 to 120, ad valorem fees. Most important point, you know, charge registration should be done within these time limits. It is from the date of creation of charge, not from the date of availment of loan. When you started using loan is not a matter. When you created charge is a matter. From the date of creation of charge, within 30 days, register charge with ROC. If you fail to register charge, charge holder can register the charge. Acquirer, you know, purchasing company, acquiring charged property should register the charge with ROC. So remember these limits: 30 normal fees, 60 additional fees, 120 ad valorem fees. And you know, this is a most expected point. I don't know why this point was tested so far. Expected point, this attempt you can expect. If a person obtains a court order for appointment of a receiver or a manager for property subject to charge, or they shall give notice to the company and ROC within 30 days of the court order or appointment of the official receiver. Notice shall also include copy of that court order or tribunal order or the charge instrument. Okay, so here the point is, within 30 days of appointment of receiver, communicate the same with company and ROC. This rule is not only applicable at the time of appointment, but also at the time of removal, termination also same rule is applicable. Communicate with ROC, communicate with the company. Charges also over. Exceptional points, that's it. Remaining are straightforward questions, you can see it. Next big chapter, management and administration. Management and administration, you know, section 88. So from 88 point of view, honestly I'm telling you, these two time limits looks very different. Entries in the registers must be made within 7 days of board approval regarding transfer, regarding transmission, or you know, allotments, bonus issue. So whatever event happens within 7 days of board approval, entries in register should be done. And this is exceptional point. What is this point? If a promoters of listed company creates any pledge on their holdings, the same must be updated in the register within 15 days. Within 15 days. SBO limits 10%, you remember. SBO limits 10%, you remember. More about SBOs, you know, if you want a summary for quick revision, you can download this handwritten marathon notes, which is already available on the website. You know, section 88, I gave a content almost 1 page. I think section 88 is covered in 1 page. In the entire section 88, you know, for me the important point would be location of these registers. First priority, registered office, or by passing special resolution you can place them at any place in the city, town, village where registered office is situated, or any other place in India in which more than, it's not greater than or equal to, it's more than 1/10 of the total members reside. Okay, next one, listed companies, you know, promoters created any charges, liens or pledge on their holdings in case of listed companies shall be updated within 15 days of such events. Foreign register, opening of foreign register, file form MGT3 with ROC within 30 days. Maintain a duplicate register at registered office. Entries must be transmitted within 15 days. Whatever entry recorded in foreign register, same should be transmitted to the head office within 15 days. Head office will update the same in duplicate register. And section 89, simple topic. Section 89, registered holder has to communicate with company, beneficial owner has to communicate with company within 30 days. Company has to communicate with ROC within 30 days of receiving communication from registered holder and beneficial owners. Normal points only, ma. Next one, SBO, you know, SBO limits, you remember, ma. SBO limits, you remember. Also, you remember this point, you know, non-applicability of SBO. Non-applicability of SBO. SBO rules are not applicable in case of government entities, local authorities, government controlled bodies, mutual funds, REAT. Next one, other SEBI regulated entities, because they are already controlled by SEBI. Some other authorities are already controlling them. So that's why, you know what, our Companies Act section 90 is not applicable. Everything was summarized. Okay, up to 7 chapters. Majority syllabus of your corporate laws was summarized in just some 80 pages, handwritten notes. Okay, fine, you will find it in the website, you can download it, you can read it. Okay, it was updated, ma, with no errors. 99.99% this document is error free. Next one, let me see exceptional topics. Time limits for closure. A company must give 7 days notice for closure of the registers, and that registers can be closed for a maximum of 30 days at a time and 45 days during a year. Cumulative closure shall not exceed 45 days. One time closure should not exceed 30 days. That is a point you have to remember. Next one, ma, annual returns ROC filing deadline. Remember, annual returns shall be filed within 30 days from the date of AGM. Okay, For all companies, MGT 7. OPC and small companies, MGT 7A. If AGM was not conducted, if AGM was not conducted, then there is no exemption on filing of annual returns. Annual returns should be filed within 60 days from the due date of AGM. Along with that, you have to specify the reasons why AGM was not held. Clear? Remember this limit. Also remember MGT 8, certification of annual returns. To whom certification of annual returns applicable? You remember. Certification of annual returns is applicable to listed companies, companies with paid up share capital 10 crores or more, turnover 50 crores or more, MGT 8 certified by a CS, certificate of holding certificate of practice. Clear? But according to me, exceptional point means time limit only. In one attempt, on this time limit only 8 marks, 4 MCQs came. May 25 attempt, Jan 25 attempt. Last year, Jan 25 attempt. On time limits, 8 marks, 4 MCQs came. That is copies of financial statements actually. Meetings held at shorter notice. Yes, of course, meetings can be conducted at shorter notice. For that, prior approval of members is required. If it is a notice of AGM, at least 95% of the members entitled to vote must give consent. 95% of the members. I'm not talking about holdings. If it is other than AGM, for companies with share capital, majority of members holding at least 95%, two conditions, majority and 95% of the paid up share capital, two conditions to be satisfied. For companies without share capital, members having at least 95% of the total voting power. Remember three limits: 95% of the members for AGM, whether it is a with capital or without capital. But EGM, company with share capital, majority holding 95% of paid up share capital. Company without share capital, members having at least 95% of total voting power. And if a member has voting rights only on specific resolutions at a meeting, they will be counted only for those resolutions where they are entitled to vote. For example, preference shareholders, matters affecting their voting rights, matters affecting their rights like reduction of preference dividend. For that particular proposal, 95% of the members means for that particular proposal, 95% of equity plus preference shareholders. That is the point meaning. So this is exceptional point only. My opinion, exceptional point. If comes, celebrate festival. Lack of quorum. Quorum is how much? 2 in case of private company, and in case of public company 5 or 15 or 30 depending on the slabs, up to 1005, up to 1001 to 5015, above 5000 30 members personally present, so proxy will be excluded. Of course, AOA may prescribe higher amount, higher number. Lack of quorum, if there is no quorum is present in the meeting, within 30 minutes of the scheduled time, meeting stands adjourned to the same day, same time, same place in the next week. But if it is a meeting called by requisitionist or called because of requisition filed by requisitionist, in that meeting if there is no quorum, meeting stands cancelled. Observe the difference. Board called meetings, board of directors called meetings, no quorum, meeting stands adjourned. Board called EGM because of requisition, requisitionists themselves call a meeting EGM. In these meetings, if there is no quorum, meeting automatically stands cancelled, no adjournment. If quorum still not present at adjourned meeting, members personally present shall form the quorum. In the entire Companies Act, one person quorum is valid only in 3 cases. Case 1, NCLT calling for AGM. Case 2, NCLT calling for AGM. Case 3, entire paid up share capital held by one person. Entire paid up share capital held by one person. In these 3 cases, one person quorum is valid. Except these 3 cases, one person quorum is invalid. Getting my point? Next one, regarding explanatory statement. Explanatory statement is required for all special business items. In that explanatory statement, interest of promoter, director, KMP, their relatives to be disclosed. If there is a transaction with another company, then directors, promoters, if they are having any shareholding in that another company 2% or more, then disclose it. If it is less than 2%, no need to disclose, materiality concept. Okay. If provisions are violated, then the defaulting persons, the penalty would be 50,000 or 5 times the benefit they received, whichever is higher. Right to casting vote. Chairman is having a right to casting vote on satisfaction of two conditions. Condition number 1, company's AOA authorization. Condition number 2, ordinary resolution. In case of equality of votes, only in case of equality of votes, chairman gets casting vote right. Getting my point? Also, company's AOA authorization compulsory. In case of no authorization by company's AOA, no casting vote. In case of no casting vote, ordinary resolution is deemed to be dropped in case of votes in favor equal to votes against. Proxima. A single person proxy can represent up to 50 members and hold a maximum of 10% of voting share capital. Getting my point? Either of the condition, either 50 members or maximum 10% of the paid up share capital. That's it. Any member holding more than 10% of the total share capital carrying voting rights can appoint one proxy, but the appointed proxy cannot represent other members of the company. Proxy had no right to speak, cannot vote under show of hands, No vote on show of hands. Proxy, of course, he can demand for poll. Voting right of a member in Nidhi company is limited to 5%, already covered in share capital section 47. Deposit of proxy forms 48 hours before commencement of the meeting. Inspection notice should be given 3 days before meeting. Inspection start time 24 hours before meeting, and inspection end time conclusion of the meeting. That's it. All the points of proxy covered. Company is required to provide e-voting. Every company which has listed its equity shares on a recognized stock exchange, except SME trading platform companies whose shares were listed on small medium enterprises, even though listed, no need of e-voting. And every company with 1000 or more members except Nidhi company. For Nidhi company, e-voting not required. That is covered in the rules, not there in our syllabus. Extra point I'm adding here. As per our study material, e-voting is applicable only to these two companies. One is listed equity shares companies and company having 1000 or more members. Who can demand a poll? Not only members but also proxy. Remember ma. Not only members but also proxy can demand for poll, but they should possess 1/10 of the total voting power or paid up value of 5 lakhs. Any condition satisfied, that's it. If it is a company without share capital, they must have at least 1/10 of the total voting power. So 1/10 of the total voting power is common, but if it is a company with share capital, alternative condition is paid up value of 5 lakhs, you remember. Next one, postal ballot. Some 10 items, postal ballot is compulsory. Of course, e-voting alternative is also there. Remote e-voting alternative is also there. But remember, my dear students, ordinary business items and items requiring director auditor's hearing via postal ballot not allowed. Via postal ballot, 6 proposals are not allowed. Let me repeat, 6 proposals are not allowed. What are the 6 proposals? Adoption of financial statements, declaration of dividends, director's appointment in the place of those retiring one, appointment of the auditor, removal of the auditor, removal of the director. These 6 proposals, postal ballot not allowed. Next one, if a resolution is passed at adjourned meeting, the effective date of the resolution would be adjourned meeting date only, but not earlier date. Next one, what can be excluded from the minutes? Chairman discretion, using these discretionary powers, he may remove following any of the 3 matters from the minutes: defamatory content, irrelevant, immaterial content, detrimental content, detrimental to the company interest. And chairman has absolute discretion in deciding whether to include or exclude the above matters from the minutes. From minutes point of view, time limits, signing of minutes time limit is also important. Not exceptional, but important. Not exceptional. Everyone knows the point. So that's why let me show it. Signing of minutes, you see here, general meeting postal ballot, signing can be done by chairman of the said meeting or director authorized by the board, and the time limit is 30 days. Within 30 days of meeting, signing should be done. Within 30 days of passing resolution under postal ballot, signing of minutes should be done. But coming to the board or committee meetings, chairman of the said meeting or chairman of the subsequent meeting can sign the minute, but for this, time limit is not applicable. Getting my point? And tampering of minutes, this is the punishment: imprisonment up to 2 years, fine 25,000 to 1 lakh. Next, resolution to be filed with ROC. If you are someone reading my material, these two points are missing in my material. Just remember these 2 points. Form MGT 14 to be filed, and the time limit for filing this MGT 14 is 30 days. Remaining content is there, ma. Only these 2 points, some printing error is there. That line was under the table. So printing error, printing issue is there. These 2 points you remember. So that's it all about minutes. Next one, ma. Circulation of members resolution, which is section 111. Section 111. So for circulation of members resolution, you know what? They must have 1/10 of the paid up share capital carrying voting rights. They must have 1/10 of the total voting power. Simply, if you see this EGM requisition majority, requisition eligibility in case of EGM, same you will find under section 111 also. Okay, deposit time limit is, if you want resolution requiring notice, at least 6 weeks before meeting you give a copy to the company. For discussions, for only discussions, no need of resolution, 2 weeks before meeting only notice shall be deposited with the company. Time period is 2 weeks before meeting. But time limit do not apply if an AGM is scheduled within 6 weeks of deposit. This is the point, ma. This is exceptionally tricky point. Generally, notice requiring resolution 6 weeks before meeting you have to deposit with company, but you gave a notice, you gave a requisition to the company. Now company conducted a meeting within less than 6 weeks. Now in that case, 6 weeks time period applicable or not applicable? Not applicable. Deposit or tender of expenses, some reasonably sufficient to meet circulation expenses, must be deposited or unconditionally tendered. So with this, yeah, majority, MGT exceptional points I completed. Remaining points are like, special notice, time limits for AGM, that all are routine matters only. Routine matters, that's why I'm not covering here. Next, dividends. So we completed half of this document. Okay, so dividends, transfer of profits to the reserves is at the discretion of the company. There is no condition on the company to transfer certain portion of profits to the reserves before declaration of dividends. Before declaration of dividends, there is no such condition. You transfer certain portion of profits to the reserves. It is completely at the discretion of the company. Company may transfer any portion of profits to the reserves or may choose not to transfer any amount, not at all. And 4 conditions to be satisfied for declaration of dividends out of accumulated undistributed profits in case of current year, any inadequate profits, in case of inadequate profits in the current year, losses or inadequate profits. 4 conditions you remember, ma. Average rate of dividend shall not exceed last 3 years average rate of dividend. Of course, this condition is not applicable in case last 3 years if you didn't declare any dividends. And total amount from accumulated profits that can be withdrawn is 10% of paid up share capital or free reserves. Maximum withdrawal is 10% of paid up share capital and free reserves. Post withdrawal, balance in free reserves shall not fall 15% of the paid up share capital as per latest audited financial statements. So simply free reserves minus 15% of paid up share capital. So this one, or 10% of paid up share capital plus free reserves. This one, out of these two, whichever is less you take. From this amount, first you set off current year losses. That amount is eligible, that amount is available to declare and distribute in the form of dividends among the members. Nidhi companies can pay dividends. Remember this point. Nidhi companies can pay dividends by crediting members' account if not claimed within 30 days. Directly credit the dividend amount to the members' account if not claimed within 30 days from the declaration. Next one, exemptions from punishment. Dividend could not be paid out. Generally if dividends are not paid, within 30 days, punishment attracts 1,000 per day. During such default continues, imprisonment up to 2 years, and company has to pay interest of 18% per annum. Defaulting directors get punishment, that one. Company has to pay 18% interest per annum. That is common. But in the following 5 cases, there is no punishment. What are those cases? Operation of law, shareholder direction cannot be complied with, and information, this is important point. Information to the shareholder is important. Cannot be complied with alone is not enough. Information to the shareholder is also important one. Next one, dispute regarding ownership of the shares. Dividend has been adjusted against the dues. Default because of external factors that is not within the control of the company. Next one, ma. If dividend payable is 100 or less, the company can announce dividend in local language in local newspaper and notice board. Display on the notice board for at least 3 months can be expected if question paper is tricky. Can be expected. Clear? Dividend payable is 100 or less. Announce the dividend in local language and display that notice in the notice board for minimum of 3 months. In the entire dividend chapter, regarding time limits, just one simple chart. Day 0, this is declaration date. Here dividends were declared. By day 5, deposit dividend amount in a separate bank account. And by day 30, payment of dividend should be done. Payment of dividends. If not, I'll treat this as day 0. From here onwards, within 7 days, by day 7, transfer unpaid amounts to unpaid dividend account. And from here onwards, within 90 days, prepare a statement containing the details of the members not claimed the dividend, their latest known address, and dividends that were due. Incorporate these details, publish it on the company's website and government notified website. And from here onwards, wait for 7 years. After that, dividend amount, and if dividends are not claimed 7 years consecutively, then shares also will be transferred to IEPF account. This is the timeline chart. Can I proceed? Next, dividends over. I took 5 minutes to complete dividends. Accounts of companies. Next chapter, accounts of companies. First one, OPC. Let me strike off this one, not required. OPC, small company, dormant company, eligible startup private companies are exempted from cash flow statements. Startup companies are exempted from cash flow statement. OPC, small, dormant, startup companies are exempted from cash flow statements. Physical books must be kept in India. Daily backup on servers must be located in India, and central government can direct preservation beyond 8 years. Generally, books of accounts should be preserved for 8 years. But in any investigation, if central government ordered for longer period, then company has to maintain books of accounts for the longer period. And within 15 days of written request, company must produce foreign financial information to the requested director. This is regarding inspection of books of accounts by the director. Inspection of books of accounts. A director can request foreign financial information. Within 15 days of request of foreign financial information, company must produce that information to the requested director. Exemption from consolidated financial statements preparation. 3 conditions to be satisfied. First one, our company C Limited should be neither listed nor in the process of listing, and it should be either subsidiary or wholly owned subsidiary to another company. Our C Limited is having another holding company. First of all, C Limited is having subsidiary. C Limited is also having a holding company. Now here C Limited can take a privilege of exemption of CFS preparation when if its ultimate holding company prepares CFS including the figures of C Limited and S Limited, and C Limited should receive no objection from all other members. Next, C Limited was neither listed company nor in the process of listing company, nor in the process of listing. So when these 3 conditions are satisfied, we can call that, you can give privilege of, that means exemption from preparation of consolidated financial statements. Remember 3 conditions. C Limited is having a holding company. So C Limited should get permission from all other members. C Limited should get a permission. This year I'm not preparing CFS. So give me your no objections. Just give me no objections certificate like that. Obtain a written consent from other members. Myself should be neither listed nor in the process of listing, and my ultimate holding company should prepare CFS considering my figures, and if it file with the ROC, then I am exempted from preparation of CFS. Voluntary revision of financial statements 131. That revision is limited to preceding 3 financial years only. How many years? Preceding 3 financial years. And revision is allowed once per financial year. Remember, say for example, right now we are in 25-26 financial year, right? 25-26 financial year. So you can go back 3 years. That means 24-25, 23-24, 22-23. These 3 years financial statements board reports can be revised because of non-compliance with section 129, 134. That's it. Once you revise, for example, company revised financial statements and board report of 23-24 financial year in this year. Next year, once again, can they revise 23-24 year financial statements? No. Revision is allowed only once. That's it. Revision is allowed only once. For financial statements, you can do revision one time. For board report, you can do revision another time, but maximum one time revision only allowed. That revision is also limited to non-compliance of section 129 and 134. Reopening of books of accounts is allowed up to 8 preceding financial years. 8 preceding financial years. Of course, reopening is possible only by court or tribunal order. Voluntary revision is also possible with authority's approval only. Without authority's approval, voluntary revision not allowed. Next one, grounds are limited to the fraud or mismanagement casting a doubt on financial information presented by the company. So this is mandatory reopening, that is a voluntary revision. So limited to 8 financial years. Remember these time limits, very I'm not telling tough, but if you don't remember, it becomes tough. Why? Because last attempt, seriously, last attempt, 60 plus marks came on limits. 60 plus marks came on limits. That means, total some 12 questions. You can see 4 MCQs were tested on limits. 4 MCQs were tested on limits. And coming to the questions also, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12 descriptive questions, there are limits. Getting it? Don't worry, for limits I'll come up with another video. Next, companies governed by NFRA. Company whose securities are listed on any recognized stock exchange either in India or outside India. Unlisted public company, paid up capital 500 crores or more, or annual turnover. See, any of the following you see. Turnover 1000 crores or more, outstanding loans, debentures, deposits 500 crores or more in the immediately preceding financial year. Also, special entities, that is banking, insurance, electricity, big companies. Next one, companies governed by special act. Body corporate incorporated by an act. Next one, entities referred by central government. Entities referred by central government. Any company, body, corporate, person referred by the central government to NFRA in public interest. And this one also tricky point. See, subsidiary associate company of entities listed above A to D, incorporated outside India, not in India, outside India, if its income or net worth exceeds 20% of the group. In the entire group, if a subsidiary is having 20% share, if that subsidiary or associate company is located outside India, that's it. Registered outside India, yes, will be governed by NFRA. Does NFRA jurisdiction end immediately once company falls below the thresholds? Another tricky point, Another tricky point. See, observe. Does NFRA jurisdiction ends immediately once company come out of these limits? No. Once covered, 3 years continuously will be covered. So that means if you are not falling in this category for continuously 3 years, then NFRA will not apply to you. So once applicable, 3 years it is applicable. So next one, NFRA is empowered to debar an auditor from providing valuation services. Maximum period of debarment that NFRA may impose is up to 10 years. NFRA can debar auditors up to how many years? 10 years. Remember students, this debarment is not only limited to the statutory audit, not only restricted to statutory audit, but also extended to internal audit as well as valuation services. Getting my point? If you are someone debarred by NFRA, you can't provide stat audit services for next 10 years. Not only stat audit, but also internal audit as well as valuation services also disabled. Next, financial statements including CFS, that is all about, NFRA. That is all about exceptional points of NFRA. If you ask me, go through these limits once. Last 2 items, May 25, September 25, duties of NFRA question came twice. Continue consecutively, that point was tested. Next, financial statements including CFS approved by the board of directors, signed on behalf of the board by the chairperson if authorized by the board, or else two directors, one must be MD. Also CEO, CFO, CS if appointed. This is for financial statements. For board report, CEO, CFO, CS not applicable. They can't sign the financials, they can't sign the board report. Only chairman authorized by the board or two directors, one must be managing director. Next one, CSR net profit calculation. Oh my god, this point I repeated twice, I think. Yeah, I repeated CSR point twice. So while calculating CSR profits, profits from overseas branches excluded, dividends from compliant Indian companies also excluded. And how to determine net worth? I told you net worth 500 crores or more, turnover 1000 crores or more, net profit 5 crores or more. Any one condition satisfied, CSR is applicable, right? So net worth calculation is sum of paid up share capital, reserves created out of profits, securities premium account, debit or credit balance of P&L account, less accumulated losses, deferred expenditure, miscellaneous expenditure not written off, and also revaluation reserves, read back of depreciation, amalgamation reserves are excluded. And about unspent CSR amounts, unspent CSR amounts shall be transferred to fund specified in Schedule 7 within 6 months from the closure of financial year. But if it is ongoing project unspent CSR amount, transfer within 30 days from the closure of financial year to a special account called unspent CSR account and utilize them within 3 financial years. Ongoing project, the duration would be more than 1 year, but it cannot exceed 3 future years. Current year you started one project, getting it? If you complete that project in the current year itself, it is not ongoing project. If it is going beyond 1 year, it will be ongoing project subject to board approval. But this should be completed within the next 3 years. Within next 3 years, if you are not completing this project or if you are keeping some amount idle, that amount shall be transferred to fund specified under Schedule 7 within 30 days after completion of third financial year. The normal unspent amount shall be transferred to fund within 6 months of closure of financial year. Within 6 months. But ongoing project, remember, time limit is 30 days plus 3 years. And after completion of 3 years, 30 days. Transfer amounts to fund specified in Schedule 7. Getting it? That means after completion of this year, you will find 3 years to complete the project, or else unspent amount after completion of 3 years, transfer it to the fund specified under Schedule 7 within next 30 days. This is another important, another important point. These activities won't qualify CSR. Yes, these activities won't qualify CSR activities. What are those activities? Normal course of business, political contributions, employee-centric welfare activities, CSR activities outside India, marketing linked sponsorships, statutory compliance expenditures does not qualify CSR expenditure. But normal course of business, 2 years COVID related research R&D expenditure was allowed as CSR expenditure. And sponsorship, market linked disallowed. And CSR activities outside India also disallowed. But if you're training some sports persons outside India representing our country, that is allowable CSR expenditure. I repeated, overseas branch profits, dividend from CSR compliant companies are excluded while computing net profit for CSR purposes. Next, if company spends more than required amount, the excess amount can be set off in the next 3 financial years. Impact assessment, remember, impact assessment is applicable to those companies who is having CSR obligation of 10 crores or more in the last 3 financial years, and impact assessment will be carried out on the projects where 1 crore or more outlay is there, and the project was completed 1 year back of impact assessment study. 1 year back only the project was completed. Now you can conduct impact assessment. For conducting impact assessment, you have to recruit independent agency, not company staff. That agency can charge fees. Allowed fees is 2% of CSR expenditure or 50 lakhs, whichever is higher. Next one, in CSR, administrative overheads is allowed up to 5%. Administrative overheads is allowed up to 5%. Remember that point. Financial statements must be sent at least 21 clear days before AGM. Circulation with shorter notice is valid if you get this much consent. If it is a company with the share capital, majority of members having 95% of the voting power, that means 95% of the paid up share capital. In case of company without share capital, consent of members holding at least 95% of the total voting power. So that much consent is required. Or else financial statements serving at shorter duration will be invalid. You remember here majority and 95%, whereas company without share capital, no need of majority, 95% of the total voting power. This is much similar to shorter notice. That is section 101. So clear? So 95% of the voting capital, that means paid up share capital or voting power. If company is having a complete ordinary shares, then 95% of the paid up share capital or 95% of the voting power will be same, same. Next one, Nidhi company. Remember this point, okay? Members holding shares of more than 1000 face value or 1% of the paid up share capital are entitled to automatically receive financial statements, and for other members, that means small members, for them publication in a newspaper and publication in the notice board which is available for inspection is sufficient. Same point I covered in incorporation chapter also. More than 1000 or more than 1% of paid up share capital, serve them individually. Rest of the members give a notice, give an advertisement in the local newspaper which is circulating in that area. Getting it? And allow them for carrying inspection activities. Enough. No need to serve documents, all the documents individually to each and every member of Nidhi company. XBRL applicability. Remember, once applicable, forever applicable. Once applicable, forever applicable. And what is the criteria for applicability of XBRL? Listed companies, paid up share capital 5 crores or more, turnover 100 crores or more, Ind AS following companies. Of course, XBRL is not applicable to this sector, this specific entities like banking, insurance, electricity. Okay, but you remember these points, listed companies as well as Indian subsidiaries. Subsidiary companies of the listed companies are also required to file financial statements via XBRL mode. Even if financial statements are not adopted in the AGM, yes, this point was tested for 8 marks in January 25 attempt, I think. Even if financial statements are not adopted at AGM, company must file them within 30 days of the AGM, and such filing is treated as provisional. Once adopted at an adjourned AGM, adopted financial statements must be filed within 30 days of adjourned AGM. Further, non-holding of AGM does not waive section 137. In such case, company must file financial statements with annexures. Also specify the reasons within 30 days. And this filing should be done within 30 days from the last date on which AGM should have been held. So that means 30 days of AGM where adopted financial statements, file them. In case of unadopted, file them. ROC will consider them as provisional. If AGM was not conducted, file them. Along with filing, mention the reasons why AGM was not conducted. So 30 days is common. If AGM is not conducted, 30 days from the due date of AGM. You all know the due date of AGM, within 6 months from the closure of financial year, right? Or the time gap between two AGM shall not exceed 15 months. Clear? Okay, fine. Indian holding company must file financial statements of its foreign subsidiaries even if they have no place of business in India. If accounts are unaudited, file unaudited statements only with ROC. If they are not available in English language, obtain certified English translated copies. If not possible, mention the reasons for deviation. Next, internal audit threshold limits. Threshold limits we have to check preceding financial year, not current year. Even for CSR also, preceding financial year you have to check. In one attempt, they gave provisional figures of the current half year information. Up to 30th September, they give one information. Preceding financial year information also they gave. Now, which information I have to consider for applicability of CSR? I need to check not current year information. I need to check preceding financial year information. Clear, everyone? Next. Yes, next one. Next point. So thresholds under section 138 should be checked every preceding financial year. Next one. At any point of time, you need to check for loans, borrowings, deposits. Turnover, paid up share capital or something you have to check for the entire year, preceding financial year. But loans, borrowings, deposits, you have to check at any point of time during the preceding financial year. Is turnover criteria based on at any point of time? No, it is for the complete year. Is internal audit report addressed to the shareholders? No. Only statutory audit report is addressed to the shareholders. Internal audit report is not addressed to the shareholders. It is in-house. Companies can have in-house internal audit mechanism also. Clear? With this, accounts of companies also we completed. And coming to the next topic, that is audit and auditors. First one, disqualifications. In the disqualifications, person or relative partner holding a security in case of company with share capital, interest in case of company without share capital. Also the group companies, I call it as cash, company, associate, subsidiary holding, disqualified. But we had an exception, a relative, aggregate basis, all the relatives of myself, all of my relatives holding up to face value of 1 lakh securities, 1 lakh face value of securities, there will be no disqualification. This is on aggregate basis, not individual basis, aggregate of all relatives. And if it exceeds 1 lakh, corrective action to be taken within 60 days, within 60 days of such acquisition or interest. Next, coming to the indebtedness, cumulative basis, that means person plus partner plus relative. Cumulatively, if indebtedness is in excess of 5 lakhs also disqualified, but if it is up to 5 lakhs, no disqualification. Up to 5 lakhs, no disqualification. In excess of 5 lakhs, disqualification. Guarantee also, in excess of 1 lakh, disqualification only. Next one. Yeah, a person whose relative is a director or KMP, whose relative is a director or a KMP, then that person is disqualified. Not only that person, his audit firm is also disqualified. Getting my point? His entire audit firm is also disqualified. A person who is in full-time employment, disqualified. Accepting more than 20 company audits, not allowed. While calculating 20 company audits, OPC, small company, dormant company, private company with paid up share capital less than, it's not less than or equal to, less than 100 crores, which has not committed default under section 92(137) or excluded while counting limit of 20 companies. Remember, no default under section 92(137). Only these 4 companies, OPC, small, dormant, private company with no default and paid up share capital less than 100 crores is excluded while calculating 20. If a person is convicted by court for an offense involving the fraud, 10 years disqualification. Convicted by tribunal, 5 years disqualification. Debarment by NFRA, 10 years disqualification. Remember this time limits. Tribunal, max 5 years. Court, 10 years disqualified. Components of the remuneration. Remuneration includes audit fees, expenses incurred during the audit, facilities provided to the auditor by the company, but excludes remuneration does not remuneration does not include payment for other service. I already gave an example, that is tax audit. Statutory auditor is also providing tax audit services. For tax audit, he took extra remuneration. He took another. He took remuneration separately. Now, tax audit remuneration, will it form part of audit remuneration? No. No. Retiring auditor cannot be reappointed in the following cases: if we do not meet qualifications, if auditor is disqualified, if auditor has given written notice that he don't want to be reappointed, or auditor has not provided a written certificate confirming the appointment or reappointment within the limits. This is implied revocation. This is express resignation. This is implied resignation. A resolution has been passed at AGM either appointing another auditor or explicitly stating retiring auditor will not be reappointed. Members passed a resolution not to reappoint existing retiring auditor. So in these cases, retiring auditor cannot be reappointed. And for removal of auditor, what? Equation should be like this: first board resolution, next CG approval, next special resolution. Don't interchange. In many questions I have seen board resolution, special resolution, CG approval. Allowed or not allowed? not allowed. Not allowed. This kind is not allowed. And for IFSC companies, you file an application with CG. If CG is not responding within 60 days, automatic approval only. Whereas in normal companies, board resolution, CG approval, after getting CG approval, within 60 days, conduct general meeting. In the general meeting, obtain special resolution. Next one, audit rotation, auditors rotation. Common partners disqualified. Next one, operating under same network disqualified. If a partner resigns from the outgoing firm and joins the incoming firm also disqualified. So these are the exceptional points in my opinion. But if you see the remaining points, if you see the uncovered remaining points, you know what? Powers and duties, just give one time reading. Powers and duties of the auditor, just give one time reading. Cost audit also, you give one time reading. Appointment of cost auditor. Who will appoint cost auditor? Members. No. Board of directors appoint cost auditor. Remuneration will be ratified by the members at the general meeting. Remember this point. Okay. Fine. Fraud reporting, one point is there, ma. Fraud reporting, auditor reporting the fraud, one point is there. So any point missed out, if I feel important, don't worry, I'll come up with another video. I'm telling you, right, we are having almost 2 days before examination, right? Okay, fine. So in my opinion, these are the exceptional points. Next one, foreign company. Let me remember. 147 punishments. 143 fraud reporting is one important point is there. Oh God. Chalo. Limits point of view. I'll come up with one more video. This is all about tricky points only. Next one, foreign company. 11th concept. Last topic of Companies Act. Deemed Indian company, please remember this definition. 50% of the paid up share capital, whether equity or preference or both, no matter. Let me tell you here. Equity 2 lakhs preference 3 lakhs. Now this 3 lakhs is held by Indian citizen. This was a company incorporated in Singapore, CINC for example, having a place of business in India. Now Indian citizen holding 3 lakhs of preference share capital, that means out of total share capital he is holding how much? 60%, which is more than 50. Now the C incorporation in India is not treated as foreign company, it is deemed to be Indian company. Getting my point? Either equity or preference or both. Remember, no need to be 50% of equity, no need to be 50% of preference. In the entire pool, 50% held by Indian citizens, Indian body corporates, combination of Indian citizens and combination of Indian body corporates. That's it. It is deemed to be Indian company. It is deemed to be Indian company. You remember that point. Foreign company incorporated outside India, having place of business in India. Let me write here. Place of business in India. Then it is deemed to be Indian company. Deemed to be Indian company. Clear? Time limit for submission of financial statements and annual returns. Yes, remember, within 6 months from the closure of financial year, submit financial statements. If you want extra time limit, ROC may grant extension of 3 months. Like AGM, first AGM can't be extended, whereas subsequent AGM can be extended up to 3 months. Similarly here, filing of financial statements, you can get extension of 3 months if you file an application with ROC citing a special reason. Every foreign company shall file annual return in form FC4. FC3 is for financial statements. FC4 is for annual returns within 60 days from financial year end, provided relevant particulars to the ROC. And this is also another important point. In case of non-registration of partnership firm, what disabilities an unregistered partnership firm will have, same disabilities you will find an unregistered foreign company also. Failure to comply with chapter 22 does not affect the validity of the contract. Contract is valid. Company is still liable. However, company cannot bring a suit, cannot claim a set off, company cannot make a counterclaim, company cannot start legal proceedings related to such contracts until it complies with the relevant provisions of Companies Act 2013. Apart from these provisions in foreign company, you will find public offer of securities, which is closely similar to foreign company, sorry, prospectus. But let me remind you here, in foreign company, one particular point, that is documents, attachments, attachments to the prospectus. Attachments to the prospectus, that is a special point. You can see here, attachments, expert consent, contracts for appointing the MD or manager. So this is my master notes, which is already available in website. Okay. Yes, expert consent, MD appointment, manager appointment. Yeah, this is the point last time they tested. Copy of material contracts entered within the last 2 years, which is completely outside the ordinary course of business. And copy of underwriting agreement, copy of power of attorney if prospectus is signed by the authorized agent. So these are the attachments to the prospectus. Just give one time reading. Next one, with this Companies Act over. Next, LLP. LLP body corporate definition is different, so just give one time reading. Body corporate means company includes LLP incorporated in India, outside India, company incorporated outside India, but body corporate excludes corporation, sole and cooperative society. Corporation, sole, cooperative societies are excluded. Financial year. Financial year with respect to company is different from financial year with respect to LLP. With respect to company, if date of incorporation is on or after 1st January, then first financial year closure date will be 31st March of following year, next financial year simply. Whereas financial year with respect to LLP is, if incorporation date is after 30th September, then financial year may end on 31st March of the next following year. Getting it? Their cutoff is 1st January, on or after 1st January, Companies Act. LLP Act after 30th September. That means first financial year maximum duration of LLP is 18 months. Less duration will be 9 months 1 day. 9 months, because exactly if incorporated on 30th September means 9 months 1 day. Sorry, 6 months 1 day. Yeah, 6 months 1 day. I'm sorry. 6 months 1 day would be the shortest duration, but the longest duration of first financial year would be 18 months. Small LLP, remember the time limits, contribution 25 lakhs, turnover 40 lakhs. And who cannot become a partner? Cooperative society, corporation, sole, HUF cannot become a partner, including partnership firm also. Unsound mind, undischarged insolvent, adjudicated as an insolvent is also disqualified. Minor also disqualified. Court or tribunal may reduce or waive off any penalty for a partner or employee of an LLP if they have provided useful information, whistleblower. If they have provided useful information during investigation of LLP, their information leads to conviction of LLP, its partners, employee under this act or any other act. So complete waiver of penalty or reduction of the penalty. And important point, LLP can maintain books of accounts in double entry system either on cash basis or accrual basis. Double entry system, pakka, cash or accrual. But for companies, cash basis not allowed. Completely accrual basis and double entry system. Every LLP shall prepare a statement of accounts and solvency within 6 months from the end of each financial year, and LLP has to file form with ROC within next 30 days. Many students got confused about this limit. Many students think that financial statements shall be filed within 6 months from the closure of financial year. No. Preparation should be done within 6 months from the closure of financial year. Statement of account and solvency means it contains financial statements only. It should be prepared within 6 months from the closure of financial year. Must be filed within next 30 days. That means mostly 30th October. Whereas annual return should be filed within 60 days from the end of the financial year closure. Even for foreign company also same time limit, 60 days from the end of financial year. LLP also 60 days from the end of financial year. Authority for compounding offenses is regional director. An offense can be compounded only once in a 3 years. That means once compounded, next 3 years if you do same offense, if you do same mistake, no compounding benefit. And compounding benefit is allowed only to those offenses where Imprisonment is not a punishment. Imprisonment is not a punishment. Next one. Transferee or assignee of a partner's rights will get only economic benefits but not management rights. No management rights. Transferee will get no management rights. That means cannot participate in management, cannot access LLP transaction information by virtue of transfer alone. If majority in number, remember, majority in number representing 3/4 in value of the creditors or partners agree to a compromise or arrangement, then tribunal may sanction that compromise. And tribunal will supervise the compromise arrangement throughout the process. If tribunal thinks compromise can't be initiated peacefully, or if modifications required, tribunal will do modifications. If at all tribunal thinks compromise is not a solution, then tribunal orders for winding up of the LLP. Getting my point, everyone? Next one, FEMA. For me, these points looks tricky. Remaining points, if you are somewhat having some good knowledge of Companies Act, majority those points only repeated in LLP. Getting it? So LLP, it's just a mixture of partnership firm and Companies Act. Flexibility of partnership kind of organization, and body corporate point of view, company status you can see. That's what. So these I found some tricky. Okay, next one, FEMA. In FEMA, person resident in India is always a favorite definition, favorite topic only. So whether a person is resident or not, you have to check first of all who is that person. Natural person, check residential status. Artificial person like companies, branches, offices, agencies, you just check place of establishment. Okay, so natural person reside in India for more than 182 days. Don't get confused, my dear students. It is more than 182 days during the course of preceding financial year, but does not include person leaving India or stays outside India because of job outside India, business or vocation outside India, intention to stay outside India for uncertain period. So these three people, even though in the preceding financial year period of stay is 200 days, for example, current financial year, these people will be treated as non-resident from the date they left our country. From the next date they left our country till the day they are in India, they are residents. After they left India, the next day onwards, they are not treated as residents. A person who has come to or stays in India, in either case, otherwise than employment in India, business or vocation in India, intention to stay in India for uncertain period. For these three people, even preceding financial year, period of stay is 0, but current financial year, they will be treated as residents. Getting it? Those who are coming to India for job, business, or intention to stay in India for uncertain period, forget about their period of status in the preceding financial year. Current year, from the date of entry onwards, they will be treated as residents. Next one, Section 6 exceptions, Resident can hold, own, transfer, invest in foreign currencies, securities, immovable property acquired when they were resident outside India, assets inherited from a non-resident. No need of approvals required for holding these assets. Similarly, non-resident holding Indian assets when he was a resident in India or inherited from an Indian resident, no need of permissions, can continue to hold those securities, assets, no problem. Next one, CAT cut, another important definitions. CAT cut. What is cut? Current account transaction which is other than CAT. Then what is a CAT? Any transaction which alters net worth of resident outside India or net worth of non-resident in India. It's very simple definition, right? Transaction altering net worth of resident outside India, that means residents net worth outside India or non-residents net worth in India, then the transaction is capital account transaction. For resident, net worth means not only assets and liabilities, but also contingent liabilities. Whereas non-residents net worth, only assets and liabilities will be considered. Now any transaction other than capital account transaction is a current account transaction, and they gave a 4 items. Imports, simply trade, short-term finance, okay, short-term finance, trade, and maintenance expenses, education, studies abroad, and hospital, medical bills outside India. All these are current account transactions specifically they mentioned. So remember, my dear students, capital account transaction means residence net worth outside India or non-residence net worth in India. If it is getting affected because of any transaction, then the transaction is known as capital account transaction. So restrictions on non-resident investments in India, chit funds not allowed, but subject to state government approval, that too on non-repatriation basis allowed. Nidhi companies not allowed, agriculture plantation activities not allowed, real estate business, construction of farmhouses not allowed. Of course, this is allowed, except means what? Allowed. REITs, townships, roads, bridges allowed. Trading in TDRs also allowed. See, I'm sorry. Trading in TDRs also not allowed. Trading in TDRs also not allowed. See, they can't do real estate activities, but they can develop townships. They can construct it on third party basis. Suppose land belongs to me, they can come and construct. We can sell it. Trading not allowed. Unnecessary, they will create demand. Like in stock market, you can see unnecessary demand for particular security. Like land also, value getting increased means if land is becoming costly, we can't pull foreign investors. That is altogether a different concept which I covered in regular classes. Don't go in detail. We are just a day before examination, right? Okay. And no restrictions on foreign exchange withdrawals for loan amortization payments, depreciation of direct investments in the business. So for carrying this capital account transactions, there is no limit on withdrawal of foreign exchange. No restrictions on foreign exchange withdrawals for carrying, repayment of loans, depreciation of direct investments. And for entities, non-individuals, LRS is applicable only to the individuals, LRS is not applicable to non-individuals. Okay, so for non-individuals, donations up to 1% of foreign exchange earnings or $5 million, whichever is lower, RBI permission is not required. Above the limits, RBI permission is required. Similarly, on a commission, residential flats, sale of residential flats or plots in India, commission, real estate commission, up to 25,000 or 5% of inward remittance, whichever is higher, RBI permission is not required. Exceeding, cannot exceed. What cannot exceed? That means if it is exceeding, RBI special permission is required. Consultancy services, if it is for infra projects, up to 10 million. Other than infra, up to 1 million, RBI permissions not required. An Indian entity cannot remit more than 5% of investment brought into India or 1 lakh, whichever is higher, as pre-incorporation expenses without RBI approval. If with RBI approval, you can go beyond the limits. All these are, within these limits, RBI permission not required. Exceeding the limits, RBI permission is compulsory. Pakka. Next one, Schedule 1, prohibited current account transactions. Just remember the list. They may ask you for 2 marks or 3 marks. For carrying these transactions, withdrawal of foreign exchange is not allowed. Remittance of lottery winnings, remittance out of racing, riding, remittance for purchase of lottery tickets outside India, exports commission where that exports were made towards equity investment abroad. Equity investments abroad, remittances of dividend by the company where dividend balancing is applicable, rupee state credit route up to 10% of invoice value. See, exception is there. Except means what? This is allowed. Except tea and tobacco exports up to 10% of invoice value, withdrawal of foreign currency is allowed. Apart from tea and tobacco, for others which are coming under rupee state credit route, withdrawal of foreign exchange for payment of commission on exports is prohibited. Callback services, payments also prohibited. Remittances of interest income, not complete balances remittances. See, you came and you deposited $1 million. By the time you are leaving country, interest some $10,000 was added, $10,000 was added. $1 million which you deposited, you can take back. But interest income on these funds held in this scheme, this amount you can't withdraw in foreign exchange. Next one, current account transactions where prior approval of CG is required. Cultural tours, Ministry of Human Resource Development, advertisements, Ministry of Finance Department, many students, they interpret this wrongly. Advertisement by state government or public sector undertakings in a media which is a print media for the purpose other than promotion of tourism, foreign investments and international bidding, that too exceeding $10,000, Ministry of Finance permission is required. Print media other than specified purposes exceeding $10,000 by a state government or PSU, permissions required. So freight vessel chartered by the PSU, Surface Transport Ministry, payment of imports through ocean transport by a government, Ministry of Surface Transport, multimodal transport operators, registration certificate from the Director General of the Shipping, hiring charges, Ministry of Information and Broadcasting, Ministry of Communication and Information Technology, remittance of container detention charges, Ministry of Surface Transport, prize money. This is also another point, prize money. Who is making payment? Other than ICC, BCCI, Tamil Nadu State Board, other than International Board, National Board, State Board, and if that amount paid exceeding $1 lakh, then permission is required. Up to $1 lakh, permission is not required. Up to $1 lakh, permission is not required. And payment is done by BCCI or Tamil Nadu State Cricket Association or Andhra Pradesh State Cricket Association, Karnataka State Cricket Association. Okay, if these associations are paying outside India, even exceeding $1 lakh also, permissions not required. Remittances for membership of P&I club, Ministry of Finance permission is to be taken. 2 hours completed. Last topic, General Clauses Act. Important points. Just I prepared a list of some 10 points, important points. So remember, preamble can never override provision. Go through may, shall means includes definition, where may should be interpreted as shall to be interpreted as may. Give one time reading. In examination, write at least half of the answer. Document excludes Indian currency notes and document includes electronic records and computer files. Document, four conditions to be satisfied. Any matter to be recorded on any substance by any means intended to be used or to be used right now and for the purpose of recording the matter, it becomes a document. So document includes soft copies also, computer files, electronic records, but remember, document excludes Indian currency notes. Next one, immovable property. Right to access. A means here, the printing error. This is tick mark. Right to access is an immovable property, whereas right to drain water is not an immovable property. Recent attempt only you have seen it. Benefits that arise in future is an immovable property. Future rents, and also a few points I have gone through very recently. Right to extract soil, that is also immovable property only. Benefits to be arised is immovable property, but benefits already arised is not an immovable property. Futuristic benefits, immovable property. Already arised, not an immovable property. Very recently question came. Arrears, rent in arrears is not an immovable property, but rents rents to be received in future is an immovable property. Effect of repeal, give one time reading. Last time it was tested, but still effect of repeal shall not have effect on ongoing investigation proceedings, rights, obligations, punishments, okay, operations. Repeal shall not have effect of some 6 points are there, 5 to 6 points. Just give one time reading. Next one, coming into the operation of enactment. If nothing is specified, the date president gave consent and was notified in the official gazette, the act comes into the force. Or if a date is specifically notified, like 1st January 26, from that date onwards, the new notification comes into the force. Next one, prosecution under 2 enactments is allowed, no debar. Prosecution, that means inquiry, investigation, is allowed under 2 acts, but punishment is not allowed. If offense is covered under 2 acts, same ingredients are there, no unique ingredients, no distinct ingredients, same ingredient. If punishment is covered under 2 acts, punishment wise not allowed, but prosecution under 2 enactments is allowed. Where statute requires registered post acknowledgement due, service by registered post alone is insufficient. So you have to serve document by registered post acknowledgement due. Refusal to accept registered post amounts to deemed service. If you are not accepting registered post document, we assume it was properly served, you received it. Citation by short title and year is also valid. Citation of acts. I can call Companies Act 2013 or Act of 18, Act number 18 of 2013. I can call it like that also. Notification can be modified only by another notification published in the official gazette. Of course, yes. Internal circulation, internal modifications not allowed. If you want to modify notification, fresh notification to be given in the place of old notification. Internal circulars will not change notifications. Power to issue includes power to amend, vary, rescind the notifications. Notification and rules continue in force unless specifically withdrawn. So that is effect of the repeal. Gazette publication is conclusive proof of valid rule making. Next one. Powers may be exercised from time to time whenever occasion demands it. Appointment by virtue of office is also allowed. Power to appoint includes power to suspend, power to dismiss. Successor authorities can continue and implement powers and proceedings. Actions of lawful deputies or subordinates are also valid. Based on this last attempt, I think 5 marks. Theory, I think 4 to 6 marks. That means 2 to 3 MCQs came. Lawful deputies or subordinates can execute actions, and those actions are valid only. From excludes first day. Duties can be calculated on pro rata basis. Male includes female, singular includes plural unless expressly mentioned. Like, woman director. There woman means not men. Getting my point. Next one, previous year. Their singular means not plural. Previous year means previous year only. Bullock cart. Bullock cart means bullock cart. It will not include cow cart. Getting it? Next one, distance shall always be measured in straight line on a horizontal plane. So all the points in General Clauses Act I covered. Of course, some definitions are there. Some definitions, year, calendar year, financial year, good faith. Just give them one time reading. For me, two definitions are very important. That is document and immovable property. I covered these two. Balance, just give one time reading. You know what? I covered 20 pages document exceptional topics in just 2 hours 10 minutes, 130 minutes. Okay, this document is available in the description. Go and download this document, give one time reading. It boosts up your confidence. Again, I'm telling you, confidence kills your fear. You will perform very in a good way in the examination. Once again, all the best to your exams. Sorry, all the best for your exams. Chalo, we'll meet in another video. Until then, see you. Take care.